15 minutes, we'll open up the floor for questions, and our speakers will do our best to answer those. If you have questions in the meantime, you can drop them in the chat if you're worried that you'll forget them between now and then. And then before we get going, we're curious if we could have any reporters on the call chime in with their name and outlet. And so you can unmute and tell us really quickly or drop that in the chat, whatever's easiest. Cool. Okay. Well, I will make so feel free to drop that in the chat. It looks like you guys do not have the option to unmute. So great. I will turn this over to Adam, and he can tell us all about this case.
All right. Thank you, Kayla, and thanks to everyone for attending. So I'm going to give just about a 10-12 minute overview of what this case is all about. I'm going to start just giving some general background about the case and the sort of factual legal issues that are at play. Then I'm going to give you some information about administrative law judges who are really at the center of this case. And then I'm going to finally talk about potential impacts, implications that this case might have. So first of all, the issue that's before the court in this case is whether administrative law judges, often called ALJs, at the Securities and Exchange Commission, the SEC, are officers of the United States within the meaning of the Appointments Clause. In other words, the court is considering whether or not it's constitutional for federal agencies to employ ALJs for enforcement proceedings if they have not been appointed under the requirements of the Appointments Clause, which is part of the Constitution. This case is going to be argued this Monday in front of the Supreme Court. So this Monday, the 23rd, they're going to be hearing oral argument on this case. So before we get into the sort of case background, I just want to define a couple key terms. So administrative law judges, ALJs, they're at the center of this case. They are federal agency employees who preside over administrative hearings. At the SEC, they adjudicate enforcement actions. Now, despite the somewhat misleading name, they are not Article III judges. Okay, they are part of the executive branch, and they are hired and paid by agencies. The Securities and Exchange Commission, the SEC, is the federal agency that regulates securities in the United States. It's an independent regulatory agency. It's headed by a 5-member commission, and the commissioners are appointed by the president with the confirmation of the Senate. And then the sort of key constitutional issue that's at play here has to do with the Appointments Clause, which is part of Article 2, Section 2 of the Constitution. The Appointments Clause requires that officers of the United States have to be appointed by the president with Senate confirmation. So the commissioners of the SEC are officers of the United States because they're appointed by the president and confirmed by the Senate. Meanwhile, Congress can authorize the president, the courts, or the heads of departments to appoint what are called inferior officers in the Constitution, and Congress sort of gets to determine what those are. Now, some background on the case. So Raymond J. Lucia and Raymond J. Lucia companies, who are collectively just referred to as Lucia, were accused of violating the Investment Advisors Act by the SEC. So an ALJ from the SEC adjudicated the case and ruled against Lucia. Lucia petitioned the SEC for review, and the commission sided with its ALJ. So an ALJ adjudicated the case, and then Lucia petitioned to that 5-member commission, which did not accept his petition for review. Lucia then took the case to federal district court. He received an adverse ruling and then took that to the DC Circuit, who ruled against him again. So Lucia has got his final appeal to the Supreme Court, which granted cert back in January. And again, they're going to be hearing oral argument this Monday. So what kind of legal argument is Lucia making here? So at the time of Lucia's case with the SEC, the commission allowed its own staff to appoint administrative law judges without the approval of commissioners. So Lucia's ALJ was selected in this way. Regular agency staff, rather than the commissioners, picked the ALJ. Under Supreme Court precedent, an officer of the United States, for purposes of the Constitution, is one who exercises significant authority pursuant to the laws of the United States. So Lucia is arguing that because the ALJ at the SEC exercised significant authority to interpret and apply the law, he must be considered an officer, and thus his appointment was unconstitutional. That's the argument that Lucia is making. because the ALJ was selected by agency staff rather than by the heads of the SEC or by the president. Lucia here is asking, at a minimum, he wants a new hearing before an adjudicator appointed under the Appointments Clause. But furthermore, he's actually asked the Supreme Court to outright dismiss the SEC's enforcement proceeding as sort of a second threshold that the court may or may not reach. The SEC has contended that its ALJs are employees, not officers, and that their appointment is not covered by the Appointments Clause. The SEC has argued that because its ALJ decisions are ultimately reviewable by the 5-member commission, its ALJs do not exercise the sort of significant final authority that would qualify them as officers. There have been a couple notable developments in this case. First off was a similar case a couple years ago, Bandemir v. SEC, where the 10th Circuit, so not the DC Circuit where Lucia's case happened, but the 10th Circuit, held that an ALJ at the SEC was in fact an inferior officer, not an agency employee, and had been appointed unconstitutionally. So since this conflicts with the DC Circuit's ruling, that I think was a big reason why the Supreme Court took up the case, because there were conflicting circuit rulings. Now, in November of last year, while the case was on appeal to the Supreme Court, the Solicitor General, Noel Francisco, who's a Trump appointee, actually reversed the administration's position. Originally, the administration, the Justice Department, the Solicitor General were defending the SEC. But in November, they reversed positions and were essentially arguing in favor of Lucia, arguing that the ALJs at the SEC were inferior officers for purposes of the Appointments Clause. A day later, after that announcement, the SEC announced that its commissioners had voted to ratify its own ALJs, sort of attempting to mitigate that legal challenge. Because if the SEC's ALJs are inferior officers, then the SEC commissioners would potentially have the power to appoint them without any sort of presidential or Senate confirmation. But if ALJs are bona fide officers of the United States, they would need presidential appointment and Senate confirmation. So now that we've sort of talked about the case, I want to kind of zoom out and give some key facts about administrative law judges in general, what they are and what they do, in particular at the SEC and at the federal government in general. So first at the SEC. According to the Office of Personnel Management, which oversees ALJs, there were 5 ALJs working at the SEC as of March 2017. So these ALJs preside over administrative hearings. At the SEC, ALJs handle what are called enforcement actions, where they act essentially as a judge and a jury in a proceeding that is essentially a trial. And the ALJs are responsible for determining questions of fact and law as to whether or not a law or regulation that's administered by the SEC was violated. So in Lucia's proceeding, the SEC's ALJ heard testimony, including expert witnesses, took documents into evidence, considered objections, weighed evidence, made factual findings, and reached legal conclusions. So sort of all the activities of a judge this ALJ was carrying out. There's a couple interesting statistics we found about ALJs at the SEC. In recent years, the SEC has won about 88% of the cases that it's sent to its own ALJs. That's compared to a 63% win rate when the SEC takes its cases directly to federal district court. In 2012, the agency actually won every in-house adjudication that it conducted. And in 11, 13, and 14, it won more than 75% of its own ALJ proceedings. But in those same years, the agency prevailed in less than 75% of similar judicial proceedings in front of a legit judge. Right, so now let's back up a little bit even further and talk about just ALJs in general. So like I said, only about 5 ALJs work at the SEC, but there are nearly 2,000 working across all federal agencies. Most of them, the vast majority, nearly 1,700, are handling cases for the Social Security Administration. At the Social Security Administration, the ALJs are mostly hearing cases about benefits eligibility rather than enforcement actions. The position of ALJ itself was actually created in 1946 by the Administrative Procedure Act, which governs how ALJs are appointed. ALJs are actually not hired directly by agencies. They are recruited and examined by the Office of Personnel Management, who then offers agencies essentially a list of candidates that they can choose from. Then agency hires people, hires ALJs that the OPM recommends, and the agencies pay them. So OPM does not employ or pay the ALJs, but it does recruit them, examine them, make sure that they sort of fit qualifications. Furthermore, ALJs are not at-will employees. They cannot be hired or fired at will, and they can only be removed from office for good cause by an agency called the Merit Systems Protection Board. So finally, now that we've sort of talked about the case itself, talked about ALJs in general, why does this case matter? Why does the outcome of this case matter? What could happen? So first of all, the case could impact ALJ independence. If the court finds that ALJs are officers of the United States, their protections against removal might be unconstitutional, right? So if the court finds that they are officers of the United States that have to be appointed by the president and confirmed by the Senate, then it may be unconstitutional to protect them from removal. The Supreme Court may find that. Furthermore, this ruling could affect pending cases. There are pending cases at the SEC and also cases from SEC law judges that are on appeal in federal court right now. These pending proceedings and pending appeals could be challenged if the presiding ALJs were or are appointed unconstitutionally, if the Supreme Court finds that ALJs are officers or inferior officers. And finally, cases at other agencies could be called into question. This case is unlikely to affect the Social Security Administration, which is the largest employer of ALJs, because benefits eligibility cases are a little bit different than enforcement actions. But across all the agencies that use ALJs for enforcement actions, there's nearly 150 ALJs that are used for that purpose. Those sort of cases at other agencies could be called into question, again, if the Supreme Court holds that ALJs are officers of the United States. So those are some of the potential impacts of this case. So thanks a lot for listening. I encourage you to visit the Administrative State Project to find out more about this sort of thing. And I'm going to turn it over to Kayla and Mark. Thanks so much for listening.
Cool. Yes. If anyone has any questions immediately, they can drop them in the chat. Otherwise, I will turn the time over to Mark Chenoweth.
Well, thank you, Kayla. Thank you, Adam. Adam, I think, did a nice job, a nice neutral job of giving the play-by-play on what's happening in this case. Let me see if I can provide a little color commentary. Some of the major concerns with the SEC's ALJs that the new Civil Liberties Alliance has in this case are that the ALJs are neither independent nor expert. That is, contrary to what you might think about agency adjudication, the ALJs are not independent of the SEC, nor do they bring any securities law expertise with them to the job. Worse yet, regardless of how they are appointed, ALJs conduct trials without juries, without due process, and without any of the procedural protections that defendants would enjoy in federal court. And so that means that these ALJ trials are really trampling the civil liberties of defendants who are unfortunate enough to find themselves in front of the SEC for an enforcement proceeding. Let me unpack those. That may sound like very aggressive claims, so let me unpack that a little bit, and maybe I should begin with clarifying one thing that Adam mentioned. While it's true that the SEC can hire its ALJs through the Office of Personnel Management process that Adam referred to, where OPM would offer up 3 top candidates to the agency, and the agency would pick one of those folks to be an ALJ. The SEC has been routinely circumventing that appointments process, and instead it has been hiring its ALJs laterally from other agencies. And while that's technically allowed under the law, there are some problems that arise from that, and 3 of the 5 current ALJs at the SEC were hired via this alternative process of lateral hiring, and at least 2 of those 3 were hired laterally from the Social Security Administration. So why does that matter? And this gets back to the points about a lack of independence and lack of expertise. So first of all, from the expertise standpoint, Social Security ALJs, as you might anticipate, have no prior securities law expertise. And a lot of times when you hear folks talk about administrative adjudication or administrative agencies, the reason why they think it might be okay to reduce the amount of civil liberties that defendants might have in these situations is because there's some theory that experts are deciding the cases. But the expertise emperor has no clothes when it comes to ALJs at the SEC. The other problem with hiring these ALJs from some place like the Social Security Administration is that those judges are used to adjudicating benefits, not rights, and certainly not the individual liberties of someone whose very livelihood is being taken away from them. Furthermore, this process of selecting from I think Adam said some 1,700 ALJs at the SEC, it allows the SEC to effectively select candidates that they believe will be favorable to the SEC. If you go through the OPM process and you have to select one of the 3 candidates who the OPM put through some sort of merit selection process, there's less chance for the SEC to handpick candidates who they think will be favorable. But when they can select just about anybody from among the 1,700 Social Security Administration judges out there, you can imagine that the SEC has an incentive to pick folks who will be favorable to the agency. And so I think that helps explain some of the numbers that Adam gave about the fact that the SEC's win rate in front of its own judges is at that 88% or 86% level, whereas the win rate is much lower than that, as low as 63%. I think, Adam, was the number that you used in front of federal district court judges. The other point about expertise that I should mention is that the SEC knows that this is a little bit scandalous, and it's tried to avoid being forthright about the fact that the SEC ALJs have been selected through this alternative process. And so I think it's important that NCLA's brief exposed this fact and brought it to the court's attention in the Lucia case. I also mentioned that the ALJs have a problem with lack of independence from the agency. And so let me unpack that a little bit as well. The first way that the judges are not independent is that they're required to favor the SEC's legal position on rules and on the constitutionality of the agency's action. So what that means is if a defendant might go into federal district court and the defense might be, well, yes, I did what the agency said, but it's not against the agency's rule, and furthermore, the agency's rule is unconstitutional. That sort of line of defense is just simply not available when you're being tried in front of an ALJ at the agency, because the ALJ is not allowed to decide that the rule is improper or that it's unconstitutional. And so that's a big institutional bias against defendants in these proceedings. The other lack of independence factor to think about is that even though it's true that the ALJs can only be fired for cause and through the Merit Systems Protection Board process, the SEC has other ways of affecting the employment of these ALJs. So we already talked about how they're selected on the front end. You can imagine some bias that might come there from having been handpicked by the agency. But even on the back end, there's room for bias. So for example, the SEC could just fire all of its ALJs if it decided that it wasn't having a very good success record in front of them. You might think that sounds radical, that would never happen, but it's exactly what another federal agency did just a few years ago. The Commodity Futures Trading Commission did that. It simply got rid of all of its ALJs because it was losing in front of them. And you should I think it's highly likely that the SEC's ALJs are aware of that sort of background threat that the agency has if they start ruling against it too often. And then an additional factor, maybe the last factor that I'll mention about lack of independence, is that if a defendant loses in front of the ALJ and it wants to appeal that, the first appeal is to the commissioners of the SEC, that is the people who were prosecuting him in the first place. So you can imagine that you're not going to get a particularly good appeal result when your appeal is to the very person who's bringing the prosecution against you. So again, lack of expertise, lack of independence, and then the third thing I mentioned that's problematic with these adjudications is that you don't have the procedural protections that you would have in a federal district court. So the discovery rules are different. The amount of time that you're allowed to prepare for your defense is vastly reduced. The ALJ can take judicial notice of certain facts and then force the defendant to disprove those facts. So it sort of switches the burden of proof onto the defendant, which does not happen in federal district court. And so these lack of procedural protections, the lack of due process, the lack of jury, and so forth, all create a pretty toxic stew for defendants to try to work against. And they don't have a choice about it, right? The agency is the one that has the choice whether to proceed against a defendant in front of the ALJs or to take that defendant to federal court. The defendant has no choice in the matter, and a lot of defendants ultimately settle because they run out of resources to try to go through the entire administrative adjudication process, then an appeal process, and only then would a defendant have a chance to go through federal court, and in this case, all the way up to the Supreme Court. You can imagine that that's very expensive and time-consuming. Furthermore, even when the defendant gets to federal district court after having gone through this process, the federal district judges have to defer to the ALJ's findings of fact and to the legal decisions of the agency. So it's really stacked against a defendant when there's this ALJ process. So the good news is that a victory for Mr. Lucia in this case would be a first step toward a more constitutional system of adjudication. Ideally, the new Civil Liberties Alliance would like to see Article III courts with truly independent judges and all of the procedural protections that the Constitution and the Bill of Rights affords defendants pertaining in these cases, and not have the ALJs deciding these cases. But we recognize that the court won't be able to do all of that in this case. So this is just taking a brick out of the wall, if you will, that exists. And maybe I'll just make one other point here, which is getting back to the Appointments Clause issue, where the Appointments Clause has been followed at the SEC. For example, in the selection of SEC commissioners, you actually see that folks with securities law expertise are selected, regardless of whether it's Republicans or Democrats, whether it's someone appointed by President Trump or President Obama or other presidents before. The SEC commissioners themselves, appointed and then confirmed by the Senate, have tended to be people with securities law expertise, regardless of whether they might have more of a background as doing securities defense work, or they may be a securities activist, more favorable to the agency's views. They have expertise. But where the Appointments Clause has not been followed, as in the selection of ALJs, we see that we've wound up with people who do not have securities law expertise. So you have this lack of expertise, the lack of independence, the lack of due process. And this isn't just true of the SEC. This is true of other agencies as well. So even though I've focused on the SEC today, and the Lucia case only focuses on the SEC, if this brick is taken out of the wall in the Lucia case, that will affect ALJs in other agencies as well. Although I do agree with what Adam said, that it's not likely to affect the Social Security Administration. And I think that I'll just leave it there for now and see if there are any questions.
Cool. Okay, great. If we have any questions, feel free to drop those in the chat. I think I just changed the settings so that attendees should now be able to unmute themselves if they want to ask a question. But I would like to start us off and kind of ask who the other groups are that are involved in this case and where do they fall in terms of their thinking on it. I don't know, Adam, if you want to start that and fill that for us.
Sure. So there's a number of groups that have filed amicus briefs in this case. Excuse me. There have been a number of sort of conservative and libertarian, institutes that have filed. The Pacific Legal Foundation. Excuse me.
Cato Institute, Washington Legal Foundation.
Yep.
Are a couple others. Chamber of Commerce.
Yep. And then there have been a couple filings from groups of administrative law scholars, a couple professional organizations that represent administrative law judges have filed briefs in this case as well. A couple like capital management type firms and law and legal firms have also filed. And then a couple professors have filed briefs as well.
Cool, thank you. And then another question where someone is wondering if you can clarify if an officer can only be appointed by the president or by the head of an agency.
So, do you want to go ahead, Mark?
Well, my understanding is that an officer can be appointed by either. That under the Appointments Clause, it could be the president or it could be the head of the agency. But in this case, at the SEC, the ALJs were appointed and selected by the chief ALJ, who was not the head of the agency, and therefore that was the source of the violation of the Appointments Clause.
Right, and there are sort of two types of officers, I guess. There are officers of the United States and then inferior officers. And the Constitution allows Congress to vest appointment power in the president alone or in the heads of departments or in the courts for inferior officers. Whereas officers of the United States, so people like, the Secretary of Defense or people like that, have to be appointed by the president with Senate confirmation. Yeah.
Awesome, thank you. And then I'm personally curious which justices you guys will be paying most attention to during arguments on Monday. I don't know, Adam or Mark, either one of you can fill that.
Well, it's a good question, but honestly, I think there's a decent chance that this could be a 9-0 decision. The Supreme Court itself has never held that a federal adjudicatory officer was not an officer of the United States. If you look back at the other cases where this has come up for other agencies or tax court judges or whatever, the court has never held that. And so I think it's relatively unlikely, particularly given that the Solicitor General switched sides and that the administration now agrees with Mr. Lucia that the administrative law judges at the SEC are officers of the United States. So I think really where the action is on this case is in the places where the parties don't agree. So for example, what's the remedy going to be that the court will order in this case? What the agency would like to see the court offer is a do-over in front of a properly appointed ALJ. And while Mr. Lucia would settle for that, what he'd really like is an outright dismissal. After having gone all the way up to the U.S. Supreme Court, I think the prospect of going back and starting this whole process over again, I mean, like Adam said, he's already gone through the ALJ process, the appeal to the agency, federal district court, federal court of appeals at the DC Circuit Court of Appeals, and the Supreme Court, if he has to start over at the beginning in front of a new ALJ, that's not a wonderful solution for him. So he would like outright dismissal, but for understandable reasons, the agency doesn't want to see that. And so you might see a split on the remedy. And the government and Lucia also don't agree on whether the court should deal with the ratification issue. So even though the fact that the SEC, I think, Adam, I think you mentioned this, that last November, the SEC sort of tried to ratify the previous appointment of all the ALJs by the chief ALJ of SEC by kind of adopting their appointment, and the commission as a whole, as the head of the agency, saying, yes, we ratify this, we recognize that these are the ALJs we want, we're now sort of effectively appointing them ourselves. And although that couldn't undo the previous adjudication of Mr. Lucia because it had already happened before that, there is an issue in this case about what happens if the court should order a do-over in front of a properly appointed ALJ. Would it have to go to a new ALJ? Could it go back to the same ALJ it was in front of before? Is that ratification that the agency did enough to make all of the ALJs there now properly appointed? The SEC says yes, that this ratification was enough. Mr. Lucia and his legal team say, heck no, that's not enough. This sort of ratification is inadequate to solve the constitutional problem. And the SG, the Solicitor General, does not want the court to reach that issue. SG has said it would be premature to decide that partly because Mr. Lucia has not been tried in front of one of these ratified ALJs, and partly because if it were sent back, the SEC could retry him in front of a new properly appointed ALJ. So the government's arguing that issue shouldn't be reached. Mr. Lucia wants the court to rule that the SEC's ratification order is invalid right now and sort of force them to start over and actually appoint ALJs in a constitutionally proper way rather than just ratify the unconstitutional way in which they were previously appointed.
Cool, thank you. We have two more questions. I'll take one of the shorter ones first. Do plaintiffs have recourse to judicial review of ALJ decisions?
My understanding of that is yes, but only after they've appealed to the commission. So if you get a decision from an ALJ, the next step is the SEC itself. And only once the commissioners have ruled do you get to take the case to federal district court. So you don't get a direct judicial review of the ALJ.
That's exactly right. And then, as I alluded to before, even when you reach federal district court, the federal district court judge is not reviewing the case anew. So, for example, the legal decisions that the ALJ made about the SEC's legal doctrines and so forth that are in the case, the federal district judge doesn't automatically have to accept those, but it gives a lot of deference to those decisions. So even when you get to federal district court, the deck is stacked against the defendant, and the factual record that the ALJ assembled is admitted into evidence, and the district courts do not, only the rarest of cases do the district courts challenge the factual record that it gets from the agency. So again, it's not as though once you get to federal district court, now it's smooth sailing. You still have the battlefield tilted against you if you're a defendant. It's much better if, in those cases where the SEC chooses to go to federal district court in the first instance, and the federal district court is assembling the record, that's a different situation, because then you have all of the procedural protections and due process and everything that the Bill of Rights guarantees you applies there. The real problem here is that we have executive branch officials doing judicial branch activities. That's the problem with ALJs.
Cool, thank you. One more question in this vein, and then our last question kind of shifts over. So if the if the SEC ratification order was invalidated, then what happens to all the cases heard by those ALJs?
Do you want to tackle this, Mark? I'm not quite sure. I suppose that depends
Sure.
sort of what the justices think, right?
Yeah, it would depend a lot on sort of the scope and the contours of the order. You could imagine it having sort of different degrees of significance. At the outer margin, you could imagine that cases that are completely over and decided are completely over and decided. So if someone's already settled with the agency, I don't think those cases would be reopened. But in terms of pending cases, I definitely think that the agency would have to redo that. And we've already seen this similar sort of issue crop up. President Obama on January 4th of, I think it was 2013, purported to appoint members to the National Labor Relations Board. The problem was that you can only recess appoint people when the Senate is in recess, and the Supreme Court found a couple of years later that the Senate was not in recess that day, and therefore those appointments to the National Labor Relations Board were invalid, unconstitutional. And the NLRB had to go back and redo all of those cases that it had done while it was being overseen by unconstitutionally appointed members of the National Labor Relations Board. So there's a lot of precedent for what would have to happen. And one of the reasons why I actually think the court won't reach this ratification issue is because it wasn't terribly well. I don't mean not well briefed as in they didn't do a good job. I just mean it wasn't really argued extensively in the courts below. And the court doesn't usually like to reach these issues when the parties have not discussed them in detail. Some of the amicus briefs, not the new Civil Liberties Alliance amicus brief, but some of the other amicus briefs do go into this issue in greater detail. But I suspect that the court is going to be reluctant to reach the ratification issue since the parties didn't spend a lot of time on it in the lower courts.
Okay, cool. Thank you for those answers. So this question is a little bit of a shift. It'll be an interesting note to end on. The gist of the new Civil Liberties Alliance perspective is that one ought to question the idea that the SEC's ALJs actually have relevant experience. So the question from this panelist kind of shifts and says it isn't about it's about expertise in general in the administrative agencies. The Wall Street Journal suggested recently that some of the administrative agencies are enthralled to junk science. How would one approach all of these in terms of a non-biased research program?
Well, I'm not sure that I understand the question, but one thing I would note is that there's a difference here again between cases that are brought in front of administrative law judges and cases that are brought in federal district court. There's a Supreme Court precedent called Daubert, D-A-U-B-E-R-T, that sets out the process that federal district courts have to follow if they're going to make rulings on scientific evidence. And it's a decision from the early 90s that's been through a lot of been applied hundreds of times, probably thousands of times in the lower courts now. It's very well understood what the standard is and how federal district courts have to deal with scientific evidence. And it was that decision was codified in an amendment to the federal rules of evidence that took place, or that was put into place about 20 years ago. And so those federal rules of evidence apply in federal district court, and it helps to keep junk science out of the courtroom. When you're in front of an administrative law judge, the federal rules of evidence do not apply, and the Daubert decision does not apply. And so you do have a risk that administrative agencies and ALJs are admitting junk science into their decision making. I hope that answers the question. I'm not sure if I understood it completely.
Cool. I think so. We can follow up with an email too, if that doesn't answer it. Okay, well, we are coming up against the end of our time, so I just want to thank both of the panelists so much for coming. I really appreciate, Adam, your preparations, and then we were so lucky to have some independent analysis today from Mark Chenoweth at the new Civil Liberties Alliance. Everyone should get an email tomorrow with a link to the recording as well as the brief that we wrote up that I linked earlier in the chat today. And then you can feel free to reply to that, or if you have any questions that you want me to direct to the panelists, or if we can help in any other way. Awesome. Thank you everyone so much for your time today.
Thank you. I really appreciate the invitation, and folks can go to NCLA's website at nclalegal.org, nclalegal.org for more information, including the amicus brief that we filed in the Lucia case.
Cool. Okay. Have a lovely afternoon all. Bye.